Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the losses of Rajiv S. Khanna PC. This is our bi weekly community conference call. Today is April 2nd. We have this call every other Thursday. I was telling people just before we started the recording that if something is wrong or something comes up, you can always tweet to me. I'm watching my Twitter. My Twitter handle is immigration.com without the dot, immigration.com. You can also tweet to us directly from our website, immigration.com. On the right hand side, there is my Twitter feed, and you can also tweet from there if something is not working out. By the way, our social media is all up on immigration.com. Facebook, Pinterest, our apps for Android as well as iPhone, our YouTube, LinkedIn, Facebook, everything is up on immigration.com homepage. Do feel free to connect with us. Okay, let's get started. As is our norm, I will start first with the frequently asked questions, and then we'll take all the posted questions and then start with new questions. So the first frequently asked question is about dual intent visas, and I want to cover that. I think it's an important topic. So I might take about 2 or 3 minutes to cover all the issues concerning that. Bhavna has a naturalized US citizen who wants to apply for Bhavna's green card. But what if the company sponsors L1A? Will the L1 be denied because of my green card application? I have a tourist visa. If I apply for a new tourist visa, will that be denied? Very, very, very excellent place to talk about dual intent visas because both of them are represented in this question. See, normally, when you have a green card application pending, you have exhibited immigration intent. You've clearly told the government, look, I want to go and live in the US. So, filing of a green card is exhibition of an immigration intention. However, there are certain kinds of non-immigrant visas that are immune from the poison of immigrant intent. Those visas are called dual intent visas. Dual intent visas, even though they are non-immigrant visas, allow you to have a green card application either filed or almost approved or pending or intended, no problem at all. And L1, L2 are examples of dual intent visas, as are H1 and H4. Okay, so these are the visas where even if you have a green card going, there is absolutely no problem. But tourist visas, student visas, exchange visitor visas like J visas, H2B visas, these visas do not allow you to have an immigration intention. So let's look at it. A visa, B visa, tourist visa is not a dual intent visa. You can't have a green card going. Let's forget about C, D, E, F. Student visas don't allow you to have a green card pending. E1, E2, E3 are kind of okay. It's a little complicated, but overall, they are pretty much to the level of dual intent visas. G, which is for World Bank employees and multinational international organizations employees. They are also dual intent visas. H1, H4, dual intent visa. I visa, nobody really cares that much. It's the journalist visas. J visas are not dual intent visas. K visas, which is fiancés, etc., are dual intent visas. L visas are dual intent visas. M are not dual intent visas. P not dual intent. Q not dual intent. Are probably okay to have a green card going. Um, and that pretty much covers all the visas that are most frequently encountered. So it is important to understand the distinction between dual intent visa, which allows you to have a green card going, and single intent visa, which does not allow you to have a green card going. So if you have a green card going and you apply for a tourist visa, that can be denied. Not necessarily, but that can be denied. Okay. She also wanted to know, once my dad becomes a green card holder, he can apply for me. I am single, over 21 years of age. You can have Bhavna, you can have green card going in many different categories. There is no law that says you have to apply only in one category. Okay. So she says, what happens if my dad passes on? What will happen to his application? Well, there are certain things that can be done. There are a couple of uh, ways out for people. I forgot the names, exact technical names. I think one is called survivor benefits, and the other one is called humanitarian reinstatement. So sometimes those two things can be of use. Look that up. If something is not clear, come back and ask us. Okay, I am going to open the floor for questions related to dual intent visas only. No new questions, nothing else, just dual intent. Anybody has any question about a dual intent visa, press star 5. Press star 5 on your telephone, please. Star 5. As I mentioned, I'm also monitoring my Twitter account. You can tweet to Immigration Calm. All right. There appears to be no follow-up. Let me go on to the next frequently asked question. This is also a very interesting question. So what happens if I used to work for an employer and I moved to employer B, or that employer A got dissolved and merged into somebody else? All kinds of situations. So what if after I left them, they sent me a check for a bonus? I don't see any problem with it. Why? Because that payment, even though they are paying you a bonus after you have left them, is not a violation of your status. It's reflective of amounts already earned. So while you had an H1 with these folks, you earned these amounts. They are merely paying it later. Now, 1099 is usually a bad idea, but in your circumstances, I do not see it as a problem. Okay, usually you can only do W2, Uttam, but in this particular case, I'm not quite sure how USCIS is going to look at it and what kind of questions they'll ask you. But I can tell you this: in the ultimate analysis, after you have responded and made it clear that this was money given as part of a bonus which was earned while you had an H1 with that company, so it's not new work, I don't think you're going to have any problem. Okay, so legally you are in a good position. Anybody has any follow-up questions on H1 people receiving payments? Press star 5. Only follow-up questions, nothing new, please. Okay, I have one question. Go ahead, please. You are unmuted. You have a question?
Yes, this is Uttam. That's the post I posted. Uh, well, sounds like the explanation you had was for past work as a bonus coming in, earned money already.
Yes.
But that's not the case in my situation. My situation, I moved on to a new company and they got bought by different companies. And what they decided, okay, to all our ex-employee or current employee, we are giving them, uh, I wouldn't say bonus, but it's service uh, for past service. I don't know how you call it, but I didn't do any job for them to earn that money. It's just the complimentary money. They said, okay, we'll
Um,
complement these our ex staff and current staff with some 10% of their salary or whatever that was.
well, Uttam, I have two questions for you. First
Yes,
question is, what was the amount received approximately?
3,500.
That's a small amount, okay? Overall, in the scheme
Okay,
of things. So I don't think you need to worry about it. It is still part of the
okay,
same idea. You did not work for it. This money was given to you because you used to be an employee. So no problem. And second question
okay.
is for my personal interest. I think I want to apply for a job with this company. So maybe you should send me an email about what this company is at. If they're giving away free money, I certainly want to work for this company. No, I'm just kidding. It's fine. I don't see you having any trouble at all with this H1 payment. It's a small payment and it is not for work rendered. It is for past work. So don't worry about it. Okay?
Thank you.
You're welcome.
Thank you.
All right. That's a good situation to be in. Let's see. Is there any other frequently asked question? No. So let's go back to our questions in series and take them one by one. Second question was from Jay Patel, filed immigration for his brother or her brother, um, living in India since 2005. He's got two daughters who are 3 and 10. I-130 approved in 2009. Okay, Child Status Protection Act, CSPA, works like this. And there's a lot more to it, but overall, this is what you need to worry about. The time during which the I-130 was pending is disregarded. Okay, so let's say you filed I-130 and it stayed pending for 4 years. Your niece's ages will be taken on the date the green cards become available for them, which is visa dates become current, -4. So even though let's say they are 25 years old or 24 years old, because the 130 was pending for 4 years, they'll be considered to be 21 or under 21. That's how it works. Okay. So I don't think you can do anything about it. Um, the age goes on and the green card process goes on. I'm not sure what else can you do. The only thing you can do is keep the calculation in mind. And of course, once your brother gets their green card, and if the children are adults and they are still unmarried, your brother can apply for them in a separate category. In the meantime, these children can also come for student visa or H1 or do their own green cards through employment or any other means available to them. So remember, I said that earlier, that you can have multiple green cards going on. So what I'm going to do is I'm going to run through all the questions and then invite follow-ups once I'm done with that. And then we'll start with a new question. Andy wants to know, I've been on F1, then H1 since 2006. Sister has been to USA on tourist visa 4 times, but F1 was denied. After that, she still came and went. Um, what are her chances of getting tourist visa again? I think the chances are pretty good. Not sure why they denied her student visa. It looks like a good case. She's never overstayed. Go ahead and try. In a case like this, Andy, you may do well if they deny the tourist visa. This is one of those rare cases where a lawyer can actually write to the consulate in case of a denial, say, why are you denying this case? This is a classic example of somebody who's obeyed all the laws. They are a very good risk for a tourist visa. So don't worry, try it. I think she'll get it. If she doesn't, contact us or another lawyer and have them write a letter to the consulate explaining why they are making a mistake here. Okay, it may be worth something. Next question was a frequently asked question. Next question is P.I. Traus, who wants to know, I have an approved I-140, filed my 485, still on H-1B expiring 2015 December. Okay, so used to work in Texas, but now I'm working in Virginia. I want to go for stamping. Well, you have to get an H-1B amendment if you moved so far away from your original H1. Okay. I think what you should do, first of all, I don't think you are on H1B any longer because of the status violation. I think this can become a problem for your 485 also, because if you are out of status for more than 180 days, your 485 can and will be denied. Of course, you can always refile if the priority date is still current. I think this is more complicated than you think. So 2013. So I don't know how long you've been out of status. If you move without an amendment, you are out of status. And if over 180 days, talk with your lawyers. I think if I was your lawyer, I would pretty much definitely have you go for a visa stamping, come back, withdraw your 485, and if the priority date is current, file 485 again, because that 485 will be denied. If you come back on a new visa stamping, then all your sins are washed away and we can refile the 485. That's what I would recommend. Okay. But until the 485 is denied, you can use your advanced parole, you can use your EAD. I don't see any problem with that. Next question is from Darshan, who says, I'm on an H1B sponsored through a consulting company expiring March 2015. Employer applied for H1B extension in Feb. There's an RFE. So what is happening is that the end client is telling you that the vendors can change, but your job is secure. So what if there is an RFE pending and the vendor changes and they apply for an H1? The way it works is, Darshan, if there is a daisy chain of H1s, okay, there's a daisy chain of H1s. So let's say you have an RFE from vendor 1, vendor 2 has applied for an amendment. Unless the vendor 1's H1 is approved, vendor 2's H1 would not be approved within USA. So at the worst, you would have to go outside USA for visa stamping before you can start working. So it's not the end of the world. But if the daisy chain is approved, then of course you get your H1 approved within USA. Okay. So I'm not that concerned about this part. Ultimately, it does get approved. Of course, visa stamping has its own problems, but overall, that is the way it would work out. Once again, I remind you guys, I am following my Twitter feed, and if you have any comments while I'm in this engaged in this conversation, you can tweet to immigration com without dot, immigration com, or you can go to our website immigration.com, and on the right hand side there is a Twitter feed where you can tweet to us directly. Okay. So going back to the next question. This is from Geo 2008. Based upon AC21 discussion, some things are clear what is same or similar. So if the new wage is $20,000 to $30,000 more than the previous wage, is that a problem for AC21? And the answer is probably not, because a lot of things are variables. For instance, if you went from a low wage area like Arkansas to a high wage area like San Francisco, of course there's going to be a higher wage payment. That's one example. If 2 or 3 years have passed since the filing of the labor certification, 10% raise per year is not very unusual in many industries. So there are too many variables. Normally, we don't worry so much about the salary being $20,000, $30,000 more, unless the salary has doubled or tripled, in which case we have to look at things more clearly. Also remember, on November 21st, Obama did say that he will clarify in coming months that natural progression in your field is considered to be same or similar. So if you went from being a software engineer to a lead engineer to a project manager to a CTO, we will not consider that to be dissimilar. So hopefully USCIS has got that hint already. And personally, I've never had problem with the salary issue. I don't want to make a generalization to your specific case. Please have it reviewed by your lawyers. But I can tell you, generally speaking, I've never had a problem with salary. There's almost always an explanation. And even if there's a big difference in salaries, as long as the jobs are similar, we should not have a problem. Lalala2701 says, been a resident since 2008, got married to a US citizen. In 2013, remarried another citizen. We're still together. So I fit the 5-year rule because I have 27 months out of the past 5 years. Never left for more than a year since I got the green card. However, I only started maintaining my residency in 2012. In other words, between 2008 and 2012, I have been in the US only about a month a year. Well, they can create a problem with that. So 2012, I would say perhaps the easiest thing to do is to file in 2017, a couple of years down the line. But if you're adventurous, you can take a chance now and see what happens. I feel it's a it's a better thing to wait till 2017, because then you're covered by two things. You're covered by, actually in 2016 you can apply, because then you'll be covered by the American citizen's spouse rule, which only requires 3 years of um, uh, residency issues, and they'll only look at the last 3 years usually. So maybe that's what you should do. Apply in 2016, 90 days within 3 years after your marriage to the US citizen. Okay. I think that might be the way to do it. I hope you're on the phone. We can talk a little bit more about it. Next question is Sohak 430 got married last year. Wife is in India. Never been to USA. Got admitted into a business school. Can she come on an F1 instead of an H4? See, F1, like I said, is not a dual intent visa. So if their spouse is in USA, that can be considered to be an intention to stay. But here's what you should do, and I think you're on the right track. Have her apply for the F1. If the F1 is denied, she can come back on. She can right away apply for H4. Okay. So would there be a gap? That depends upon the consulate. There's one raised hand. Um, I will take the follow-up questions at the end of this conversation. So please wait. Okay. I see your raised hand. So if I were you, I would have her apply for F1. Be meticulously clear that you are in the US. Make no errors in filling out the forms, and apply for an F1 visa. If that's denied, apply for H4 visa. There might be some few days gap. I think there could be, because they might have to make another appointment. But technically, she could apply the same day if the consulate allows her to. Okay, or even at the same place. If she took her H4 papers with her, I don't know harm in trying. You can also send an email to the consulate, how they would consider the second follow-up visa if they can take it the same day. But yeah, F1 first and then H4. Abdul Chicago wants to know, wife is a US citizen. She's applied for his I-130, approved. I'm doing my J1 waiver. I will apply for 485 after the waiver is completed. Yes, good. She's a housewife, not working. How can she fill the 864? See, it's a good idea to have a joint sponsor or a co-sponsor. That way, things are very clear. And I think I know that there is a certain formula that they apply to add your income as well. But I think the cleanest thing here is if you've got somebody, member of the family or even a friend, doesn't have to be related, who's willing to stick their neck out a little bit for you and become a co-sponsor, that would take care of the problem. She files 864, doesn't have income, no problem. The co-sponsor or the joint sponsor's income is included. Okay, that's what I would do. Next question is from Amelia. Amelia says, applying for US naturalization outside USA. Amelia, I don't know of any way this can be done. If somebody is outside USA, they cannot apply for naturalization. And in fact, if they have not maintained their permanent residency in USA, they would have a big problem. They could even lose their green card. So you have more than one problems here. There are some exceptions to requirement of physical presence, but those exceptions don't exist here. For example, there's something called expeditious naturalization. So some of those are applicable to people who are married to US citizens who have been stationed abroad. None of that applies here. Your husband is the green card holder and he's moved with you because of job issues, I guess. Right. So really, I don't see what you can do here. I think he would lose his legal status if he's not living in the US. So I think he should move back to USA, domicile here, comply with the naturalization requirements, and then apply. Okay. Again, I hope you're on the phone. We can talk a little bit more about this. Next question is Ajay Garg, who says, I have an approved I-140, 485 not filed, date not current. New opportunity in the same company, same department, job category is the same. I'll be supervising few people in the new position in addition to other responsibilities. See, Ajay, this is a question of fact. Your lawyer should take a look at your case, and if the job description is more or less the same, USCIS may be tolerant of it. Okay. I don't think I can give it a percentage, but the way the government looks at it is that there should be no substantial change in the job. So anything less than 100% same is taking a chance. Um, so I really cannot predict how it will work out. If you don't want to start the perm process again and have a guarantee that you won't have to start it again, then stay where you are. If you don't mind taking a little bit of a risk, go ahead and try it. See how it works out. Okay. Amruta says, can an H4 visa, this is about H4 EAD. Can H4 visa holder travel outside USA after applying for the EAD? And the answer is we don't know. USCIS was supposed to get back with us. They'll probably let us know in a frequently asked questions. Is there fingerprinting required? I thought EAD required fingerprinting. Let me check. Sumanje, is fingerprinting required in EADs? Like if we do an EAD for 485, fingerprinting is required? Confirm with one of the people there. Also check with the Stanton crew if for L2 EADs fingerprinting is required. So call somebody and just my phone is turned off. I'm in the middle of a conference, so just knock on my door and let me know. Thank you. I'll find out for you. We'll call our Stanton office where they do the non-immigrant visas. I think biometrics would be required. I would be surprised if they're not. Okay. Next question, I'll update you in a second, as soon as I hear from my colleagues. Next question is from Pranab Kumar Kotagiri about AC21. For perm salary was 192,000 in San Francisco. From a consulting company A in San Francisco. I've applied for 85. I found a full-time employment in North Carolina. The offer is a lot lesser, 110,000. Okay, but everything else is matching. Salaries in San Francisco are a lot higher. So I personally feel you'll be okay, but I would feel a lot more comfortable if you actually took a one-on-one consultation with a lawyer. Let them compare your job descriptions. Let them look at the salaries. I personally think it can be made to work. So don't give up on that job. I'm not that concerned about it. I think it'll work. Now, I remember I had a very good friend who went from Washington, D.C. to San Francisco, and his salary was almost doubled in San Francisco, and he still found it hard to live there because the cost of living was so bad. Okay, so I think you'll be okay. I'm not that concerned about it. Smile Baba says, I'm a permanent resident, got my green card under EB2. Wife also got her green card. Can she stay outside USA for more than 6 months without jeopardizing green card? When you have a situation like this, I would like her to go for a re-entry permit I-131. And I think it could be a problem for naturalization. If your home is not in the US, in fact, and you don't live here permanently, just by coming back every 12 months, you're maintaining your green card, or so you think you are, because green card can actually be taken away if you don't live here. So it can be a problem for naturalization. It can also be a problem for maintaining your green card. Okay, so at least do the re-entry permit. Next question is from BSAC, who has a similar issue. Wife will be applying for re-entry permit for 2 years and staying in India to take care of her father. If father is sick and there really is a reason for it, I don't think that should be a problem. Of course, you lose your citizenship advantage and you got to start your time for citizenship again. But you will not lose your green card if you have a situation like that. Last question for the day is from AB5. H4EAD rule. Again, can she apply for H4 after she returns, or is H4EAD only open for a small limited time window? No, this is a permanent provision. There is no deadline by which you must apply, nor is there a window. So H4EAD will be open forever until the law is changed or the policy is changed. Can she apply and come back? We don't know that yet. We don't know that. I just mentioned that. Under the normal EAD rules, she cannot. But would they make an exception for H4 EAD? We don't yet know. Okay. Anybody who has a follow-up question, no new questions, follow-up question, press *5. There's one raised hand already. You don't need to press *5 again. Press *5 for any follow-up questions. Yes, ma'am.
Everyone is saying no, including L3 EAD.
Thank you. I am corrected that for EADs, no biometrics are needed. So it looks like we will not have to do any biometrics because L2 EAD is very similar to H4 EAD. So I suspect it will be the same policy. There are 5 raised hands so far. 5 raised hands. I'm going to start in the order people logged in. So whoever logged in the earliest gets to go first. Let's start with, let me make sure I've got everybody. Yes. Let's start with California. California, go ahead, please.
Yeah, hi Rajiv. So can a re-entry permit be filed if the person is already out of USA?
They have to be in the US when you apply. After they apply, they can leave USA. Once the application is received by USCIS, they can leave USA, but they'll have to come back for biometrics. Once you get the biometrics done, you can leave again, or you can stay and wait for biometrics after you apply. But until the re-entry permit is actually approved, I advise people to keep coming back within 6 months each time. Once it's approved, then you're good for 2 years.
Okay. Okay. Thank you.
You're welcome. All right. That takes care of that question. Let us go to our neighborhood, Virginia. Virginia, go ahead, please. Virginia.
Hi, Rajiv, sir. This is Petros. Actually, I mean, the question wasn't related to I-485.
Oh, I'm
It
sorry.
was about whether, hello?
Yeah, go ahead. Which question number, sir?
Yeah, whether number 6
Okay, let me
on
get
the
to it.
top.
I'm sorry, I must have missed it. Give me 1 second. I normally don't miss things, but it's possible.
5,
Oh,
Petros, 5.
5. Uttam, right?
Petros, yeah.
No. Oh, Petros. Okay, so that's number 6.
No, after the Uttam one.
Yeah, that's number
After
6.
the Uttam one.
No, I know you were asking about can I still go for stamping with my current H1B? And I said you have a bigger problem. I saw a problem which I pointed out. You have a bigger problem than just a visa stamping. I think if USCIS finds out that you've been out of status for more than 180 days, they will deny your 485.
No, I am not out of status. I have been on my H1. I was never been on out of status.
Hang on. Listen to me. If you work in a location for which you have not been authorized through an amendment, you are out of status.
Oh, okay.
I'm sorry I didn't explain fully, but I thought you knew that. But I understood your question, and I actually gave you more information than you asked for because I saw a problem. And I think you need to get together with your lawyers. You need to explain to them what I said, that you are concerned your 485 will be denied because you've been out of status for more than 180 days. Fix it. They can fix it. Just go with what they suggest. I think the 485 will have to be refiled.
Okay.
Okay?
Okay.
Good luck, sir.
Thank you.
Sometimes I don't have the best of news, but at least when you know the problem, you can prepare for it rather than have the problem fall on you and then running around trying to get things done. This way you can plan for things. So sorry, I wish I had better news. Okay. We still have about 4 more hands raised. So let's go to New York. New York, go ahead, please. I can hear you.
Yes, hi. I think it was question number 8, about my naturalization. And I wanted to ask, first of all, if I if I choose to file now, let's say, and I go by the 5-year rule, and and I have 3 years of continuous residency, the fact that I've been out of the country for more than 188 days in the first 2 years out of those 5, could that disqualify me?
Yes.
Because I know that if I go by the 5-year rule,
I'm worried about this. Let me tell you what I'm worried about. What I'm worried about is that between 2000 and 2012, 2008 and 2012, you really did not stay here. You were gone for 11 months in a year. Okay. So if the government decides that you lost your green card during those years, they can take away your green card. Of course, your husband can apply again and you'll be back, no problem at all. But it definitely is a hassle. I want to avoid bringing in those 4 years altogether. And the best way to do that is to file during a period where they will not go back. They can, of course, if they want to, but they will not go back. For example, if you apply as the spouse of a US citizen, they won't go back past 2013. Because if you apply in 2016, they won't go back beyond 2013. That was my thinking.
I understand, and it doesn't matter that it's a different American citizen.
Oh, how does that matter? Because with this U.S. citizen, you got married in 2013. In 2016, you would have been living with them for 3 years. That's all that's required.
Right. And let's say, what if I can prove that we've been living together for 3 years? We've been married too, but we've been living together for 3 years.
You have to be married and living together for 3 years. It's both together.
I'm sorry, I didn't hear you.
If you were living together before you got married, that period doesn't count.
That doesn't count.
No.
Okay. And just my one last question. I'm sorry. I really thank you for your advice.
My
just
pleasure.
one last question, and I will wait, of course, until 2016 and to eliminate any possible problems. But I'm also worried about something that bothers me very much. It's a long story, and I'm sure you know that there's a lot more to the story. But in general, I had a child in 2008, and it was close to when I got my green. Actually, a few months after I got my green card, and it wasn't from the person from the person I was married at the time.
Okay.
I'm very worried that it might raise a lot of red flags in my situation, and my green card will be taken away. And even though now I've been so long since then, and I've been married here for a wonderful youth citizen, we have children together, we have everything together. But I'm afraid that this past thing might raise red flags and make me disqualified for anything. Do you think that's possible? I know it's possible, but do you think it's likely? Or
you should take a consultation from a local lawyer wherever you are, because it depends upon the laws of the state. If adultery in that state is a crime and a serious crime, it could be a problem, but then again, you were never convicted of anything. Overall, I don't want to make a guess in something this important, but my feeling really is that you should be okay, but you must consult a local lawyer. Don't do anything without discussing your whole case, okay? You'll be fine. Overall, I don't think you're going to have a problem, but it should be prepared for, understood completely what your circumstances are. You'll be okay.
So you think that most likely in situations like that, as long as I meet the qualifications, the digging up the past is not usually shouldn't be concerned as much as long as I do everything and I follow up with the lawyer and everything.
I still want you to follow up just to be safe. I don't think it's going to be an issue.
I understand. I really appreciate your help. Thank you so much. It's very, very appreciated. Thank you.
You're welcome, ma'am. Good luck. Okay, we have 3 more questions, after which we will start all the new questions. Again, my neighborhood, Washington, D.C. Go ahead, please. Washington, D.C.
Sir, this is...
Yes, sir.
This is Darshan.
Darshanji, what number question are you? Do you remember? Oh, yeah, I have it.
Question number 6, sir.
7, actually. I have it. Yes.
Question number 6. One thing I couldn't understand when you explained for my query is the need to go for stamping. Actually, to clarify my question a little bit, I'm in the middle of RFE. USCIS has sent an RFE when my employer has sent the
Right, right.
H1B extension petition.
Darshanji, I understand your issue. Let me slow it down. I went into fast forward. I often do
Okay.
that because most of you guys are already so well versed. You already know so much about your situation. I don't have to break it down. But let me break it down.
Sure.
Maybe I was not clear. So let me break it down for you.
Sure.
So
Thanks.
you have end client, which is fixed, but the vendor is a moving target. It can be one vendor,
Yes.
second or third or fourth vendor. Question is, I have an RFE through one vendor pending, and the second vendor got the contract and started my H1. Right? That's your question?
I mean, it's like whatever the vendor is, there are chances that they may get changed. But
That's what I'm
the
saying.
employer will be the same.
What I'm saying is, the vendor can change. It's a moving target, but the excuse me, but the end client remains the same, right?
End client and also the employer who has filed the petition.
Okay, and client can also be employed. So in a situation like this, there are actually two possibilities. We have to look at one thing only. On the date your H1 where you want to work is approved or at least decided, are you in legal status or not? Okay, and that's what we have to go to. It's going to take me a little bit more time than we have here, but let me try to summarize it for you. So on the date your H1 is decided, whichever H1 you want to go to, there must exist a complete status for you. So that can only happen in one of the two ways. Either your earlier H1 or H1s are already approved, the extensions or the transfers, or you are still working under the terms of the original H1. Let me explain further. When does your current H1 expire?
It already expired, sir, on March
Okay,
31st.
so if it already expired, then that possibility is gone. The only way you will get your H1 within the US is two possibilities. Either if any intervening pending H1s are denied and USCIS decides to forgive you, you will get your H1 within US. Or if all the intervening pending H1s are approved, and then the H1 where you want to work is approved, you will be allowed to get H1 within USA. Otherwise, you will have to step outside USA for visa stamp.
All right, sir.
That's what I meant.
Yeah.
All right.
Okay, I got it, sir.
Good luck, Darshanji.
Thank you very much.
You're welcome. Okay, two more raised hands, and then we go to new questions. Back to New York. New York, go ahead, please. New York.
Hi, this is Deepak. This is regarding question number 17.
17. 1 second, sir.
And it's regarding,
Let me get to your question. That way I will know what we are talking
Sure.
about. 1 second. Reentry permit taking care of father, right?
yes, yes.
Yes. Okay.
Would that be fine if she works during that period when she stays there? Because,
Oh, I'm sorry.
So-
I did read that, but I forgot to address it. And the answer is yes, that's fine.
yes, sir, I didn't hear you.
I said the answer is yes, I think that should be fine.
Okay, okay. Thank you.
You're welcome. Okay. And the last question follow-up is from New Jersey. New Jersey, go ahead, please.
Yes, hi Rajiv. Thanks a lot for the chance. I actually spoke to you last conference also about my I-140 revoked from the 45 application. So I was now searching for a new job, and this is what I found. But on the other hand, I have a question: is that instead of like I have my own company, like I work for my own company since I got my EAD. So is it okay to transfer, or can my own company support my 8021? Like,
I want you
instead
to
of going to new.
I want you to have a one-on-one consultation with me. This is not an easy question to answer. It can be done. Actually, if you look at Bill Yates' memorandum of May 2005, he allows you to work on an AC-21 for your own company, but it's a little tricky because there should not be a change in job description. If you're a techie, you should remain a techie. You shouldn't become a CEO. Not until Obama clarifies that. So talk to me. I think we need a one-on-one consultation. Send me an email. We will set you up for a formal consultation. Let me go over your facts. I'll be able to at least help you safeguard yourself as much as possible.
Sure. I have a next the follow-up question here is that
Sure.
does the designation matter when we search for a new job? Like because my old job says as a systems manager, but the new client is something like giving a software engineer designation, but the description is really matching for the project. Like
I have to look at the job descriptions. One most important thing is that the job descriptions should be same or similar. See, I have seen the designation of systems manager applied to people who are basically just senior software engineers. And then I have seen the position of systems manager applied to people who are director level people. Okay. So I have to look
Okay.
at the job descriptions, compare them, and then give you an opinion. But really, designation is relatively less important. Job description is the most important criteria.
Okay, and as and I'm thankful that you told me the other point that the salary difference, looking at the location, is also not
I'm not that
high
worried.
important.
I'm not that worried. Yeah, I'm not that worried.
Okay.
Okay.
Yeah. Thanks a
Good.
lot.
You're
Thanks
welcome.
a lot, and thanks for service.
You're welcome. Good luck, sir.
Thank you.
Okay. Anybody has any question, press *5. Anybody has any question, please press *5. One question, two questions. Oh, that's easy. So we have a total of 2 raised 3. Okay, 3. Anybody has any question, press *5. Okay, so after these 3 questions, we'll call it a day. Let's start with the grand old Texas. Oh, four raised hands. Okay, go ahead. Texas, go ahead. We can hear you.
Hello, sir. I'm in J2 visa. My visa says I'm subjected to 2 and 2E.
Okay.
My wife, who is a J1, actually she is not subjected to 2 and 2E.
Then obviously it's an error, because unless she is subject to 212E, you cannot be. So what you can do is you can get an advisory opinion for the J1 holder.
Okay.
An advisory opinion for the J1 holder, and attach your papers with them, attach a copy of your paperwork, and ask the waiver review branch in the State Department to give you a written opinion. They usually give opinions only about J1s, but doesn't hurt to ask. If the J1 is not subject,
Okay.
you are not subject.
Okay, but as my visa was
I don't care.
I had an offer.
I don't care. I don't.
I had an offer from.
I don't care.
Okay, okay.
I don't care,
So
because
does it,
because the consular officers make mistakes all the time. I have seen so
Okay.
many cases where
Okay.
the visa says not
Okay.
subject to 212E and they are subject.
Yeah, even I checked with DS 2019. The first thing, I mean, at the bottom left corner, where this subjection is, mentioned.
Yeah.
There is a cross mark on the first thing that's not subjected to 2 years. But my DS 2019 form doesn't have any check mark.
Yeah, I'm not worried about it. I'm not worried about it. Get an advisory opinion about the J1 holder. See if you can also get a comment about the J2 holder, and that will clear you up. And this is free. They don't charge anything for that.
Okay, but do I need to inform all these things to her company?
No, you can do it privately. You don't need the company to do it.
Okay.
No problem at all.
Okay.
All right.
Thanks a lot.
Oh, you're welcome.
Yeah.
Okay, let's go on. We have 3 more questions and then we'll call it a day. Let's go to sunny Florida.
Hi, we received green card on July 2010,
Okay.
and we were out of country for 203 days. After that, we are here only, and we don't have any longer trips more than a month. So we want to apply in July 2015. So is there any problem?
No, in your case, because in the beginning when you got the green card, you were gone for over 6 months. But then when you came back, you have not had any long absence. I don't fear at all. I think you'll be fine.
Oh, so we can apply so that means in July our green card 5 years is going to complete. Can we apply in April?
Yes, you can. And the only thing is, when
Okay.
you have been outside for more than 180 days, they can ask for an explanation. But I am not worried since your conduct clearly shows that once you came back, you became permanent residents. I think you'll be okay. That's my guess.
Okay, but we don't have house, but we maintained our car insurance and we filed taxes and we are good. We except the house, we are on track, everything.
No, but
So we
once,
have car insurance,
ma'am,
car.
once you came back after that 203-day absence, you have never had a long absence after that, right?
Yeah, only one time we had 61 days, but the recent trip was 203 days. That is in 2013. So after 2013 May,
Oh,
we
I'm
were
sorry.
here only.
I'm
We didn't go anywhere.
Okay, so hang on, hang on. I'm a little confused. I thought you got your green card in 2013 July, or was it?
No, no, no. We got our green card in July 2010.
Oh, okay, okay. I'm sorry. I misunderstood your facts. I'm so glad you explained to me again. Okay, look, um, you have to have a very good explanation why you were gone for more than 6 months. Okay, one thing the government doesn't like is if you are gone and you take up jobs in your home country, they think of that as an abandonment of your green card. I do want you to make an appointment with a lawyer, discuss your case, get a feedback from them, what kind of issues you could have. I don't want you to be in a situation where you go to apply for a naturalization and they take away your green card. So just
Oh,
please talk to a lawyer. Otherwise, just apply in 2018.
oh, 2018.
Yep,
Oh, okay. So like, but we have our car and the
that doesn't
insurance and
matter.
bank
That
account
that
and
doesn't matter. That doesn't. Just because you park a car in USA and keep your bank account here does not make you a permanent resident.
oh, okay. So, but
Okay.
we have to take lawyer's advice
I want you
for
to.
that.
I want you to. I want somebody to sit with you, go over the facts. Why were you gone so long? What happened? When did you come back? So, all these things need to be examined. Did you have a job in India when you were gone? So all these things have to be examined.
Yes,
No, I can't
yes,
do it
but
right.
our
Ma'am, I can't do
company.
it. I can't do it. I don't have enough time here. But that's what you need
Okay,
to do. I can guide you, but I can't really give you a full consultation here. Okay?
okay,
Good
okay.
luck.
Yeah, how can we make an appointment with you?
You can send me an email to help@immigration.com.
Mhm.
Help@immigration.com.
Okay,
I'll have somebody contact you once I get
okay,
the email. Okay?
okay, okay. Thank you so much for
You're
that.
welcome. Good luck.
Thank
Bye.
you.
Okay, let's do the last two questions. Um, Back again, somebody else from Florida. Go ahead, please. Florida. Florida. Um, your
Yes,
last.
I'm
Yes,
here.
go ahead.
Sorry,
Yeah, go ahead.
I was actually muted.
No problem.
Hello, sir. How are you?
Good, good. How are you, sir?
I'm good, thanks, sir. I have a couple of questions on H4 EAD, if you can answer those. Like H4 EAD is for job or just a business? Like what kind of class it is actually?
Sir, once H4 EAD is given, that can be used for any of the following purposes: to work, not to work, to start your own business, to start three businesses, to start a business as well as do a job, any permutation combination.
So if it's a part of this combination, then how it's different from a regular EAD? Is it different from regular EAD, or it's just the same what
See,
a normal H1B candidate applies with
no,
in the
no,
regular
no.
process of the green card?
H1B candidate is very restricted. They have to work for the same employer, under the same terms, at the same job, at the same location. EAD has no restrictions.
Okay. So once a person get a H4 EAD, can that person apply for advanced payroll also?
No, they cannot. Only EAD.
Okay, so that means that's a little different from a normal regular EAD.
Well, EADs are so many different kinds. What you're talking about is a 485 EAD. A 485 EAD allows you to file an advance parole not because you are filing an EAD. Because 485 is pending, you are entitled to EAD. Because 485 is pending, you are entitled to advance parole. All these rights are coming from 485.
Okay, I got you. Okay, another thing is recently what happened with like my home address is changed actually, and when I applied for my green card, it was my older address. So is there any form which I have to apply? I need to take or I need to take a help from a doctor?
You need to do two things. Make sure your AR11 is constantly, continually updated. AR11, it can be done online.
Okay.
Once you have done that, you need to contact USCIS and put in a service request for change of address.
I need to contact USCIS for
Yes.
this, and
I'm
ask them
assuming
to update this address.
I'm assuming you don't have a lawyer, because if you have a lawyer, they'll take care of it for you. But if you don't have a lawyer, update your AR11. If you don't, you can be deported. Update your AR11 and contact USCIS to update your address for the green card purposes.
Okay, and the last question is regarding my location address change for my work. What happens is recently there's some change in the location of the work address actually. We are in the same city, but what happens is the address going to be different. So the current address was mentioned into my 140 approved notice, and now after one and a half months, the address will be changed, but we will be in the same city. So does it going to impact my process?
If it is the same city, same county, it does not affect your green card.
It doesn't affect, and we need not to inform USCIS for this change, right?
There's nothing to inform.
But I have seen that in 140 the process, I have seen the address which is shown as the current address.
I'm not worried about it. Sir, don't worry about it.
Doesn't matter.
You don't have to worry about it. All right?
Okay, that's right.
Good
Thank
luck.
you so much. That's all my questions, sir.
You're welcome. Okay, guys, let's do the last question today, and then we are done. This one is from New Jersey as well. New Jersey, go ahead, please.
Hello.
Yes, ma'am.
Hello, Rajiv. How are you?
I'm well, thank you. How are you?
Good, good. Rajiv, I have also a question on the H4 EAD.
Yes, ma'am.
I'm an eligible candidate for the H4, and I understand that there is a date has been defined that I can apply for the H4 EAD on the May 26th. And we have planned our vacation to India in the month of June. So I was wondering, is there any restriction that when you apply for the H4 EAD, you cannot travel outside the country?
I don't think you have heard my conversation today, because I've answered this question.
I logged in at 1:30. I'm so sorry if I missed it.
Yeah, I've answered this question twice.
I mean, I logged at
okay, that's okay. The bottom line is we don't know. Not yet. And hopefully USCIS will make it clear. But right now we do not know if you travel during the EAD pendency, do you have to file EAD again all over, or will they allow you to travel? We don't know yet.
Okay, and there is no specific guidelines that when we will come to know about this particular thing?
I think we will come to know probably before May 26th, but how far before May 26th, I don't know.
Okay. So I can be contacted with your office, and if at all there are any updates, will it be reflected somewhere on your website or on the immigration.com?
Of course, immigration.com, my tweets, my Facebook, even my LinkedIn account has all the updates on H4EAD. My blog has all the H4EAD updates. No problem.
Okay, that's great. Thank you so much.
You're welcome.
Thank you so much for your time.
You're welcome, ma'am. Good luck.
Yes, thank you.
Bye-bye. Guys, thank you very much for being here. As always, we truly appreciate the opportunity to serve you and do the best we can to participate in our issues. Hopefully, I will see you back again in 2 weeks. Thank you. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.